But every once in a while you come across a cooperator and you think, is it right to flip this person? Is it right to use this person to testify against someone else? And maybe sometimes it's not. One of the stories I tell about an insider trading target that we had named Noah Freeman, who had left the hedge fund industry. We were doing a lot of insider trading cases during my tenure. And he started to teach at a girls' school. And one of the FBI agents who was on a juggernaut of flipping people and rounding them up and getting them to testify against other folks approached Noah in the parking lot of his school. And almost immediately, Noah decided to cooperate. Not just cooperate in the way that some people do, which is they would agree to testify about historical facts going back in time and help you convict people. He decided to do that thing that prosecutors hope and pray for in every case. He decided to cooperate proactively. And among other things he was prepared to do was secretly wear a wire. And he wore a wire, which is not that unusual, but he decided to wear a wire against not just somebody with whom he had engaged in criminal activity, but a person who was his best friend. And not just his best friend, but the person who had been his best man, and for whom he was going to be best man coming up. And the odd thing about that is, in the messy world of criminal prosecution and cooperating witnesses, and the two assistants on this case were not, novices. They were not, school children doing this work. One had been a gang prosecutor, the other had been a mafia prosecutor, now doing securities work. And they had seen people commit heinous crimes, racketeering, bribery, extortion, homicide, brutal killings, none of which caused them to sort of be unsettled, because that's what happens, that's what you expect. And now here you had a white-collar guy who was doing something that was useful to the case, flipping on his own best friend, and that unsettled them. And you thought to yourself, and we used the testimony, and the only reason we were able to convict this other person who had engaged in this massive obstruction and gotten rid of all the documents that would have been able to prove that he had engaged in insider trading, but for the wearing of the wire, he would have gone free. It still caused people to think, was that a right thing to do? Was that unseemly? How would that have looked to a jury at trial? So there's lots and lots of moral dilemmas that arise from cooperating witnesses, as I'm sure you experienced.
Yeah, and I've been thinking about it as we've been covering one of the most distinguished residents of this part of the country, Rick Singer, who I'm sure most of you have used him as a consultant to get your kids into college, and as my family did, but what was so interesting about that case is that he's been cooperating for more than a year, and he wore wires on dozens of both his clients, the people who paid for their kids to get into school, and for the people he was paying at the various universities. And my prosecutor hat, I thought to myself, this is the world's greatest cooperator. These cases are now all slam dunks. I can't imagine any of these people are going to go to trial. I mean, what's going to be the defense? But when you think that he is at the center of this, and clearly the person who made the most money, the most responsible, the most culpable, he's going to get this tremendous benefit by this, these acts of betrayal. I think that's morally complicated.
Yeah, no, he's an unusual example. I mean, usually it's a case, you have a hierarchy, right? And you start at the bottom or you start in the middle, you go with the secretary and you flip, and they flip up because they know the comments and the negotiations and the statements and the criminal activity of the person, one step up or maybe two steps up, and then you go up a little bit further until you get to the boss in an organized crime family or in any other kind of, organized criminal group. But sometimes it's the case, like in this example, all those other bad people, those bad actors, they were not in a hierarchical group. He was the nucleus, and there were spokes out to all these other people. And so there was no other person, I don't think, given my understanding of the facts, that could have given you everyone else, even though he's in some ways the most culpable person. It was like a wheel situation as opposed to like a ladder situation. The other, by the way, point about that the college admission scandal, that to me is interesting in light of complaints made about the Mueller investigation and whether or not the Mueller investigation went far afield because they were first supposed to look at one thing and collusion, and then they found these other things, and that's outrageous, and there are these red lines. That's nonsense. That happens all the time. This college admission scandal case that I think nobody thinks is a bad case, and everyone thinks is eye-opening and is terrible, and the people should be punished. The investigation did not begin with college admissions. It began because the US Attorney's Office was looking at securities fraud, and then someone got squeezed and said, "Have I got another story for you?" And it was a total left turn, and no one is complaining and saying, "Wait a minute, you're supposed to look at collusion only." No, if you find crimes along the way, it's perfectly appropriate and right, and in fact, part of your duty and necessary to investigate those things too, in the same way that happened in the college admission scandal.
Another chapter in your book, which is not only interesting, but as it turns out, highly topical, although not what you were writing about, is the issue of what a prosecutor does when he or she decides not to file charges, does an investigation and says there's not enough here. Now, you were extremely successful in political corruption cases in New York. Your office convicted the majority leader of the state Senate, the Speaker of the New York State Assembly, but you also investigated the governor of New York, Andrew Cuomo, and the mayor of New York City, Bill de Blasio. And in those two situations, you decided not to bring charges. And unlike in most situations where prosecutors decided not to press charges, you elaborated a little bit on this. You talked a little bit about your decision not to. Talk about the moral and legal dilemmas of what you do as a prosecutor when you walk away from a case.
Just in fairness, I don't think we talked about it at any length. I think we put out in both cases like a 3-sentence statement. There was no press conference. There was no report.
But you didn't say. I mean, you acknowledged that the investigation had taken place and that it had ended. Yeah, well, in part that's because, you don't do that ordinarily. In part you do that because, in fact, in fairness to the target, because ordinarily people don't know that they're the subject of investigation, but when it becomes known because there's reporting or because people concede that they're under investigation, to remove the cloud, there needs to be some finality. I mean, in fact, in investigations all the time, in my office, and I'm sure in your former office, people are constantly asking for some statement, and we don't do it. I think that when you investigate significant elected officials, given the sensitivity of their elected position and future viability, I think you owe it to them, if you close a case, to say that you're closing a case, and then they can say whatever they want about whether they've been exonerated or not. The problem, so you're on the horns of a dilemma, right? When you decide to bring a case, and I talk about this in the book at some length, you can judge the decision to do something. You can look at the charges, they become public. A lawyer is assigned to the defendant, and the Constitution requires that under law for the past 50 years. And there's a judge, and the press can go in, and you can read the documents, and you can see the cross-examination, and you can make an assessment of whether the case was properly brought, whether it was just, whether it was tried adequately or not. Now, the decision not to do something, not to bring a charge, can't be assessed in the same way. Now, first of all, as a sort of a philosophical matter, any decision not to do something is more difficult to assess than the decision to do something. Like, how do you assess the decision not to marry someone, or the decision not to take a particular trip, or the decision not to take a particular job? You can sort of guess later, would that have been wise or not, but you can't really in the same way that you can assess things that actually happen in real time, actual eventualities that occur. So that's problem one. Problem two is, if your goal is to be fair and just, and you've decided, and this is what people are talking about these days, right? And you've decided that given what your responsibility is as a prosecutor, you have one responsibility, one duty, and it's this blunt instrument of either bringing the criminal law to bear or not bringing the criminal law to bear. So you either charge someone or you don't.
And if you charge them, like I said, you can assess it. If you don't charge them, then the argument goes, and it's a good one, although it has limits, that you shouldn't be able to get up and malign them on the way to letting them off the hook. Because among other things, they don't have the opportunity later to defend themselves with the same megaphone that the prosecutor has. And they don't have an opportunity to exonerate themselves at an actual trial that will happen in the circumstance in which you charge the person. So it's thought to be fundamentally unfair. Now, on the other hand, it's not crazy for prosecutors to want to say something. And the impulse is there. And I had that impulse on more than one occasion. And I saw what happened to Jim Comey, and you realize, resist that impulse.